Hello, my name is Sophie Millington and I'm a HR consultant at Alchemist. I've got around 10 years HR and employment law experience, and I'll be running the webinar today on handling grievance matters in the workplace. If you have any questions that you'd like to ask, we do have a question tab at the end which you can ask questions on. So that would be really good if people can ask questions, so we can make sure that we answer those. Okay. So today, the areas that we're going to be covering are what are grievances, what kind of things can cause a grievance, what the grievance process is, including grievance investigation, paperwork and appeals, when to use an informal or a formal grievance procedure, and the risks of getting it wrong. The aim of this webinar is to enable you to have more confidence in dealing with grievance matters, to recognise when to use a formal grievance procedure, as outlined in your company employee handbook, if you have one in place, to know the grievance process and the risks of getting it wrong, and be familiar with template letters that might be used for dealing with a grievance. So getting started off then, what is a grievance? It's a complaint, a problem or a concern that the employee can raise with their employer. And the important thing is, it does not have to state that it is a grievance. So what kind of issues may cause a grievance then? It can be things such as terms and conditions of employment. So, for example, people feeling like they are not being paid enough, or that they're working excessive hours. It can be a working environment, if people feel that the working environment isn't respectful or professional. It can be things like employee relations or disputes with colleagues. If there's fallings out in the workplace, it might affect morale or cause bad feeling. It can be a lack of perceived equal opportunities, if people feel they're being treated less favourably than colleagues, for example. And it can be things like bullying and harassment, people feeling that they're being picked on and they're not happy in the workplace because of that. So, what is the purpose of the grievance procedure? So the idea behind having a grievance procedure in place is that it gives employees a forum to raise any complaints or concerns that they may have, and it's a way of trying to resolve those problems. And can complaints be resolved without formal action? The answer to that is yes. You can have an informal resolution where issues might be resolved without a formal grievance procedure being used. There is something called the ACAS Code of Practice, which is used for dealing with both disciplinary and grievance issues, and that does talk about trying to resolve grievances informally where it's possible and appropriate. So that obviously would be dependent on the type of complaint in question. If it was an allegation of discrimination or bullying, something of that nature, then it obviously wouldn't be appropriate to try and deal with it informally. And in that kind of situation, you should always use a formal grievance procedure. So where the matter can be dealt with informally, we'll look at how you might want to go about doing that in some of the slides. So, what is the informal grievance procedure then? So, the informal procedure would normally be used by the employee's line manager, and they would normally have an informal meeting with the employee. But obviously, if the employee's issue is with that line manager, then the informal meeting would need to be held by a different manager or a company director, so somebody in quite a senior position in the company. The informal meeting, for the informal grievance, you should have a comfortable open atmosphere. ensuring there are no interruptions to the meeting. For example, things like mobile phones ringing, people coming in to the meeting room. Make sure you allow the employee to air their concerns. So try not to cut people off if they're trying to elaborate or talk about their feelings. Ask sufficient questions to ensure that you have a full understanding of the matters that they're raising. So the situation they might be in, how they're feeling. Make sure that you take notes, either you take notes yourself or notes are taken by somebody else, so that you can use them if you need to ensure or clarify any issues, your understanding of things in the future. And if things went further to tribunal, that you would have a record of the conversation. And it's really important to always ask the employee how they would like the matter to be resolved at the end of that meeting, so that you understand what action they are looking for moving forwards. If they're wanting certain action to be taken, or they're asking for information, or that, that they've got concerns, they're wanting something to be done that might involve colleagues, for example. So you do need to understand that. It's very important you understand what they are looking for. So when you are handling or trying to handle a grievance informally, you can look at whether there's a quick or an immediate resolution. So consider whether a solution can be reached immediately. If anything crops up in the meeting that seems very straightforward or is within your authority to organise, then, if that is possible, agree that solution with the employee and reflect any agreement that's reached in the meeting notes as well, making sure that all notes are placed on the employee's personnel file, and make sure that any agreed solution or action is acted on or taken as soon as possible or within the agreed time frame, to avoid that informal grievance being escalated to a formal grievance. Making sure that you've agreed any proposed timescales for dealing with matters. If you're looking to try and handle a grievance informally and there is no immediate resolution, it might be that an investigation is required. And if that's the case, you would agree next steps with the employee and explain that you are needing to undertake an investigation. That would involve you going away and promptly speaking to all appropriate witnesses. So, for example, if the employee has named colleagues or other people in the business who may have relevant information, who may have seen or heard things, they would need to be spoken with, and ideally a statement taken from them. And then you would obviously need to look at challenging responses in order to ensure that the matter is fully understood and appreciated by all concerned. And you'd need to analyse any appropriate key information. And for the outcome, you might want to meet again and communicate your findings and any actions you intend to take, and again making sure notes are placed on the employee's personnel file. So moving on from the informal grievance procedure and looking at the formal grievance procedure. I mentioned the ACAS Code of Practice for dealing with grievances and disciplinaries earlier on, and the ACAS Code of Practice does give key principles for employers and employees to follow in handling grievance matters. So employers and employees should deal with issues promptly at all stages. They must act consistently, carry out investigations. That's obviously the employers, acting consistently and carrying out investigations, making sure that employees are kept informed at all stages of the grievance process, and giving employees a full opportunity to put their case forward. Of course, employees do have the right to be accompanied to a formal grievance meeting, and that can be by a work colleague or a trade union representative who is appropriately qualified and experienced. and employees do have the right to appeal against any formal decision that's made. So, for example, if a grievance was rejected, the employee, if they weren't happy with that, could lodge an appeal against that decision. And employees should also be given the 48 hours notice of a grievance hearing taking place. Okay, so looking at that in more detail then, in terms of handling grievances formally, you would really need to look to arrange a grievance meeting, and again make sure the employee fully understands the grievance process. So the person dealing with the grievance, when they write out the employee to invite them in for the hearing, they might want to send a copy of the grievance procedure from the employee handbook. Arrange the meeting, explaining in the letter that the employee does have that right to be accompanied to the meeting by a work colleague or a trade union representative. The employee would have that meeting scheduled usually within the normal working time, and that they would be given time to arrange to be accompanied to the meeting, and that time should be treated as normal working time and paid. And the employer or the chair of the meeting should arrange for a note taker to be available. So ideally you would have your formal notes of the meeting. So very similar to the what we've talked about before with the informal procedure. A formal grievance meeting, again, does need a comfortable open atmosphere with no interruptions. The employee must be given full opportunity to air their concerns and their feelings. So it's not appropriate for the chair of the meeting to cut them off or to interject too much. And certainly no outcome should be given during the formal grievance meeting itself. The chair of the meeting should ask sufficient questions, again, to understand the matter, summarise their understanding of key issues to ensure accuracy. Again, ask the employee how they would like the matter to be resolved, and again, agree next steps so the employee is clear on what's going to happen next. The grievance investigation, you would obviously make sure you've spoken with all relevant witnesses. Question and challenge responses, again, to ensure the matter is fully understood and appreciated by all concerned. Make sure that notes have been taken to have an accurate record of the meeting. Look at any information. It might be that the employee has passed on emails or letters or feedback forms or some sort of information that needs to be interrogated and looked into. And it might be that further information needs to be sought and located. So if the complaint is against another person, for example, a colleague, once the grievance has been dealt with, there may be other procedures that come into this as well. So after the grievance has been resolved, it might be that other actions taken, such as the use of the disciplinary procedure, for example. I would say that grievances and disciplinaries do sometimes do get interlinked and connected with each other. So that's something to be aware of. Looking at the grievance outcome then, unless you sort of agree otherwise, you should really be writing to the employee with a full explanation of your findings and the reasons for those findings as soon as possible. Usually that would be within 5 working days. If, however, that's not possible because there's missing information, people are on sick leave or holiday, or some sort of other statutory leave, then you would obviously need to write to the employee to explain any delay in providing the grievance outcome, because otherwise it might obviously aggravate the situation. They feel they're being left without a resolution. And obviously, if your handbook commits to a certain timescale, such as 5 days for giving a grievance outcome, you don't want to breach or not follow your own company grievance procedure. You would always inform the employee that they have the right of appeal after they get the grievance outcome. That would be in the grievance outcome letter that would go out to them, and make the employee aware that if they do need to appeal, who they should write to, and the timescales for that. We'll come on to appeals a bit later on, but they would normally be within 5 days of receiving the outcome letter. So if it was agreed to communicate the outcome at a meeting, then you'd need to look to schedule a grievance outcome meeting at a mutually convenient time and location for the employee. And again, they would have if they wish to be accompanied to that meeting, they could be. Again, you would take notes if you had another meeting with them. And again, you would basically follow up with anything that's been agreed. Making sure you place copies of all notes, evidence and letters on the employee's personnel file. So there's a few different possible outcomes for a grievance. You can either look to reject the grievance that the employee's raised if you find no evidence to substantiate it. If you don't believe it's appropriate to withhold it or take any to uphold it or take any action. The alternative is if you have found evidence or information that substantiates what the employee is complaining about, you would obviously have to uphold their grievance and explain what action you were taking to remedy the situation. And also, there might be some situations where you might reject part of an employee's grievance but uphold a different part of it. So you might find some evidence that points towards what they're complaining about, but not all the evidence that backs everything up. So if they've raised a number of different grievances or types of complaint, you might find some of them do need upholding and other parts need rejecting. So again, your outcome letter would need to be very clear as to which parts have been accepted and the reasons for that, and why some parts were being rejected. And obviously, a grievance outcome will be based upon reasonable evidence. So what evidence has been found during the grievance investigation. And obviously it should be reasonable and promptly communicated to the employee. So I mentioned grievance appeal earlier on. That's available to anyone who sort of isn't happy with the grievance outcome that they receive, and you as a manager or a company director would need to arrange to hold a grievance appeal meeting with that employee. The important thing is it must be a different member of staff to whoever has heard the original grievance meeting. That's to ensure or try and ensure perceived fairness and impartiality. You must make sure the employee fully understands the grievance appeal process. Usually it would be, as I say, a different person, and usually it's a more senior person to the first person who's held the grievance meeting. They should chair that appeal meeting. Again, the employee has the right to be accompanied by a work colleague or a trade union representative, and that is a statutory right. So it's very important that that statutory right is always communicated in the correspondence, in the letter to the employee, and that the company doesn't do anything that could be perceived as trying to make it difficult for the employee to be accompanied to the meeting. For example, things like giving insufficient notice, changing dates or meeting locations without giving adequate notice to the employee. That would be seen as being quite unfair and unreasonable in the circumstances. So the company would have to write to the employee, explaining all about the meeting, explain what the appeal procedure is, which should be outlined again in the employee handbook, and allow the employee to arrange to be accompanied. And again, have a note taker present, which is very, very important. So the grievance appeal meeting is largely similar to what we've talked about already for any type of HR meeting, in terms of having the open atmosphere with no interruptions. It's not an opportunity for a complete rehearing of the original grievance. It should really focus on the specific areas which employees are dissatisfied with regarding the outcome. So I would say you'd be focusing on the grounds of appeal, the reasons why the employee isn't happy with the outcome they received. Again, you'll be asking questions to check that you understand the matters with notes, and summarising understanding of key issues. Again, looking at how the employee would want the matter to be resolved. Normally, they'd perhaps be looking for a different outcome, so make sure that is looked into, and agreeing any next steps, so the employee is clear what's going to happen next. And again, you'd look to be writing out to the employee to outline any findings and reasons for those, and being very clear that the appeal is the final step in the process for internal HR matters. So there is no further right to appeal, and the employee must understand that. So there may be action they take afterwards, but it would be sort of outside the company's internal procedures, such as going through ACAS early conciliation and looking to enter an employment tribunal claim. And we will come on to that a bit later on in the webinar. So for the grievance outcome, again, you would just keep copies of all evidence and notes on the personnel file, exactly as we've talked about already. So just moving on to the relevant or key pieces of legislation which which could be involved in grievances. So the Equality Act 2010 is the legislation that deals with discrimination. I've already mentioned the ACAS Code of Practice. That's not mandatory. That is something that tribunals would take into account. They'd look at whether it had been followed or not when dealing with grievance matters, and if there was an unreasonable failure to follow the ACAS Code of Practice, that can result in an uplift in damages against the employer. So in terms of looking at possible outcomes, and these are sort of worst case scenarios. So hopefully for the vast majority of cases, if grievances have been dealt with appropriately, the meetings held using the right invite and outcome letters and the right to appeal, then in the vast majority of cases, the employee perhaps decides not to take any further action. But if things either aren't dealt with appropriately, or if the employee still feels very aggrieved about matters, then there's a few things that employees should be aware of. In some situations, you might get an employee claiming they haven't been adequately supported or procedures not been followed, and looking to resign from their employment. And if they do that, then they can look to bring a claim for constructive unfair dismissal. And that's something that can obviously be quite an issue for some businesses, because they then have to look at defending those claims or trying to reach settlement. And there's also, if an employee feels they've been treated less favourably because of a protected characteristic, there's also the risk of potentially of a discrimination claim. So for things such as unfair and constructive unfair dismissal claims, the employees do need 2 years service, continuous service with the company to enter those claims. But unfortunately for discrimination claims, there is no qualifying length of service for those. So for example, you could as a business receive a discrimination claim from someone who hasn't even been directly employed by you. They might just come to interview and maybe not be successful, but there's no length of service requirement for a discrimination claim. Okay. Looking at the documentation then, that as an employer you might want to have these in place, and these are things that we can help with as a consultancy business as well, specialising in HR. You should always be looking to induct new starters and have an induction form or checklist document that shows what's been done, what training's been covered, making sure you have done your eligible to work in the UK, so right to work in the UK checks prior to the employee starting to work for you. They must of course be copies be taken of those. So if you check someone's passport, that would need to be scanned or photocopied in a form that can't be edited and kept on the personnel file before they start work for the business. If it's done after they start work for the business and there's a problem with they're eligible to work in the UK, then you wouldn't be covered there. So that check would be done and should be kept with their induction. And some businesses use offer of employment letters, which go out before the employment contract. The important thing is that the terms of the offer are very clear, and we would always suggest that you do send an offer of employment letter as soon as you have concluded what the offer will be and discuss that with the employee. Employment contracts must be issued to employees at the very latest within 8 weeks of their start date. Ideally, it would be done at their induction. So my view is it should be done as soon as possible to avoid any problems or misunderstandings. You as a business should also have an employee handbook, and that should be made available to all your new starters, and they should be issued with an employee handbook signature form to say they've read and understand the employee handbook. And that is a document that will contain things like your equal opportunities policy, the grievance policy, disciplinary policy. Those really important policies that employees might need to refer to during their employment. So some businesses have employee handbooks that have contractual effect, and some are non-contractual, but it should always be very clear what the situation is. And again, as well as the contract and the employee handbook, you would normally have a probationary review form and carry out reviews during the probationary period, and at the end of the probationary period, which may commonly be either 3 or 6 months, you'd be writing out to the employee to confirm if they'd passed the probationary period, if it was being extended, or if sadly things hadn't worked out, if their employment was being brought to a close. So for all the documents, the employment contract and the employee handbook, you as employers or managers in a business must ensure that you have up-to-date documents, so copies of the most current employee handbook. If you are one of our clients, then whenever your consultant updates the employee handbook, that gets uploaded onto HR Guard. So you must always make sure you're referring to the most recent one and not any old copies that have been downloaded to computer desktops or anything like that. Make sure that you are familiar with the employee handbook and you understand it. I would say that some of the most important policies are as I said, disciplinary and grievance, and we do offer HR training on how to deal with those types of issues as line managers in the Managing People course that we can run. So looking at the slightly negative side of things and the risks of getting it wrong in relation to how you manage people and deal with issues that they may raise, such as grievances. For tribunals, an employee who leaves a business, whether that's by resignation or being dismissed, has a time frame to enter an employment tribunal claim against the business. So usually employees have 3 months less 1 day from the effective date of termination. But what's happening now is the ACAS early conciliation process is being used, and where both parties are entering into ACAS early conciliation, that stops the clock. So that would extend any time frame for an employment tribunal claim to be made. That does extend the deadline. And if you as a business are unfortunate enough to receive an employment tribunal claim, we as a service could support with that. We do have a relationship with an advocates firm who can support with defending claims at tribunal. But as an employee, you have 28 days to respond to that claim. And if you do not issue any sort of defence, if you don't respond to that claim to on what used to be called an NET3 form to defend it, then you won't be able to defend it in the future. Okay, so you get a default judgment. So the important thing is, if any documentation comes in, that you get in touch and seek legal advice as soon as you can. And of course that you check your insurances that might be in place. You might have a legal indemnity insurance through ourselves, or alternatively your own insurance cover, which you could have sort of director and officers policy, which might cover you. So you should always check your insurance cover before you look at who you're going to instruct to deal with a tribunal claim. So in terms of tribunal awards then, if you were unfortunate enough to have an unfair or a constructive unfair dismissal claim against the business, it would any financial award, if you were not successful in defending the claim at tribunal, would be made up of 2 awards. So 2 different elements to the financial award against the business. One is called a basic award, and the other is a compensatory award. So the basic award at the moment could be up to £15,750, and it's based on the equivalent of a statutory redundancy payment. And the compensatory award would be lower of 52 weeks gross pay, or capped at £86,444. So that's assessed, known and anticipated losses. So I know it sounds scary, but that's why it's important to sort of take advice and to follow procedures to try and avoid any sort of risk of a tribunal claim, because it's quite expensive if you are unfortunate enough to be unsuccessful in defending one. So looking at tribunal awards a bit more, and specifically discrimination. If an employee successfully claims discrimination, and that could be on its own as a standalone claim or in addition to another type of claim, then the amount of compensation for discrimination, that is actually uncapped at the moment, it's unlimited. So there is no upper limit on compensation for in terms of financial loss. So it could literally be hundreds of thousands of pounds if it was unsuccessful. Compensation can also be awarded for injury to feelings, which is a non-financial loss, and that can be looked at in terms of what's called the Vento bandings as well. So that's a bit of information about tribunal claims and potential damages, which hopefully, as I say, hopefully most people won't need to go into that too much, and would have more just been looking at how to deal with grievances and the right letters to use. In terms of the documentation that we've touched on, if you are a client of ours, we do have all our template letters for grievances on the HR Guard system. And if you're not a client of ours and you wanted to get in touch or speak to somebody, then feel free to do that when you get the details on the slides, the information slides, and we can look at sort of supporting, if possible. Okay, so we've had some questions come through, which is great. Our first question is, should you issue the employee with copies of the investigation notes as part of the grievance outcome? So should you send the notes that you make when you're investigating a grievance to the employee along with the grievance outcome letter? So the first thing is, I would say, is that you would have to check the company policy if you specify in your policy, if you have a very detailed grievance policy. But my view is, as much information as you can provide to the employee that explains, what you've done as part of your investigation, who you've spoken with, and how you've reached your outcome, is good, because it shows that you've done a thorough grievance investigation, and that you've been reasonable in how you've dealt with things. So I would suggest, if you feel it's appropriate, that you do include some of your investigation information along with the outcome letter. What I would say is, you do need to check there's nothing in the investigation that is confidential or sensitive in relation to either the company or colleagues. So if there's any personal information in there that might be sensitive, that involves any of the employee's colleagues, that would need to be redacted. So you're not sending information through about anybody else to that employee, as that obviously wouldn't be appropriate. So that's the first question. And the second question that we have is, what should an employer do if an employee raises a grievance as part of a resignation? So if you get a resignation letter from one of your employees that talks about them being very unhappy at work, and that's why they're choosing to leave the business, what you should do in that situation. So the starting point there is to hold an exit interview with the employee, which you should always really look to do if somebody leaves the business and you're not quite sure why. The reason for that is you want to prevent high staff turnover and the cost of the business of training new staff, for example. It's all time and money. And you'll want to see if you can resolve the employees' concerns, hopefully with a view to keeping them within the business. So it might be that you're able to smooth things over, deal with any specific issues, or if they're raising concerns about management, look at training or other things you can do to try and keep them in the business, if possible. So that's what I'd say to do there. Okay. And our next question is, if an employee is being disciplined, so having disciplinary action taken against them, and as part of the disciplinary they raise a grievance, does the disciplinary action against them have to stop? And the answer to that is no. Otherwise, many employees would be raising grievances whenever they were disciplined. You can continue with your disciplinary, as you would normally do following your disciplinary policy as per the employee handbook. But if the grievance is linked to the disciplinary, then you would need to obviously deal with both of those issues, and you might need to deal with them together if they are connected. If the grievance is against the person who is chairing the disciplinary matter, then it might be appropriate to actually get a new chair for the person who's looking into the grievance, just because it's not appropriate if they've raised concerns about that person and they are dealing with the outcome of the grievance. Okay. And our final question is, can an employer take disciplinary action against an employee if they raise what appear to be either multiple or vexatious grievances? So if you have a difficult employee in the business and they seem to be raising complaints, every other week, or being negative about colleagues on a regular basis, how should you handle that? My view there is that you don't want to look as if you are treating an employee less favourably because they are raising grievances, because that could appear to be victimisation. So what I would say is, if somebody is raising several grievances or grievances that appear without any merit, I would advise in that sort of situation that you consider mediation. So meeting with the employee to explore the fact they appear to have raised several grievances recently, they appear to be unhappy at work. Can you try and explore with them, find a root cause of why they're raising so many grievances and see if you can deal with that. So I would say mediation would be preferred as opposed to taking disciplinary action against somebody who's raising many grievances. Of course, if mediation isn't successful and somebody, if they were causing problems to the business, you have a number of options available to you. If the employee had less than 2 years service and no protected characteristics, so for example they were not pregnant, disabled, ethnic minority background, transgender, and those sorts of things, then you could always explore the possibility of carrying out what's called a short service dismissal, because the employee with less than 2 years service does not have any unfair dismissal rights at that point in time. So that's an option available to you, but the preferred thing to do really is to mediate, understand where the employee is coming from if possible, and try and deal with that to keep them in the business, and to identify any underlying problems that it might be that people need more training or more support at work. And of course we can help with any HR training as well if people need that. And that looks like it is all of our questions. So I'd just like to say thank you very much for joining us today. I do hope that you found it useful. There is a very short survey at the end of this webinar, and if you could complete it, we would be very grateful. As I said, if you need any help or guidance on grievances or any other HR matter, please do contact us at Alchemist PSM.